Okay, thank you, Sandy, and thank you to all of the organizers of the symposium. So I'm going to focus on the question of what variables go into the risk assessment instruments and whether reliance on those variables is constitutional. I'm not going to focus on machine learning methods. The examples I'll give will have to do with what Sandy called checklist instruments, which are basically, they're based on past regression studies of prior offenders, and regression coefficients are sort of loosely translated into numbers of points on a risk that go into a risk score. So a judge in, say, a pre-sentence investigation report or something is presented with a probability of reoffense based on extrapolation from prior offenders. In any case, my view is that if the variables you are relying on are unconstitutional and inappropriate, they will remain so whether you're loading them into a regression-based instrument or a machine learning algorithm or whatever. Sandy mentioned most of this has been set forth in more detail in the law review article. If you want a much shorter version, you can look at the Federal Sentencing Reporter. My written work has focused on sentencing. That's also what I'm going to give examples on today, but basically the same arguments apply to parole, which is a much older usage, and really to a lot of other uses in the criminal justice system, such as in bail. I am mostly going to focus on equal protection concerns. I want to briefly mention a couple other constitutional objections one might have to these instruments. First, there are procedural due process concerns related to the lack of transparency. So it may be true, for instance, that the instruments that Richard has been working on, the code is available to anyone, but the instruments, the checklist instruments that are vastly more commonly in use already in the criminal justice system today, the most common ones are proprietary corporate instruments in which the weights, that is the number of points associated with particular variables, is actually not made available to defendants, and I think that that is a concern. There's also an issue of, potentially an issue of self-incrimination, because defendants are being told that participation in risk assessment interviews is effectively mandatory. But I mainly want to focus on a substantive question of is it okay to sentence people based on who they are and their socioeconomic backgrounds, in addition to their criminal conduct? What variables are in the instruments? Well, different instruments vary, but there are some commonalities. So surprisingly, almost none contain really any details at all about the actual crime for which the defendant is being sentenced. All of the instruments do include several variables related to prior criminal history. Most also contain gender, age, employment status, education level, and marital status. The most popular instruments, like the LSIR and Compass, include a whole battery of more detailed background factors, such as financial problems, past or present trouble paying bills, reliance on social assistance, whether parents or other family members have a criminal record or have been to prison. Compass asks whether your parents used drugs, whether the defendant or any of his family members has been a crime victim, whether the defendant lives in a high crime neighborhood, quality and stability of accommodations, failure to participate in organized leisure activities like clubs. Look, on policy grounds alone, I think we should be concerned about this. Essentially, if you wanted to come up with a list of every possible indicator of socioeconomic disadvantage you could think of, that's pretty much what say, LSIR and Compass have done, and all of those are risk-heightening factors, right? I think it is certainly bad policy for the state to direct judges to deem classes of people more dangerous and sentence them for longer or let them out of prison on parole later on the basis of their poverty and their demographic characteristics. Beyond being bad policy, though, a harder question is whether it's unconstitutional. So I'm not going to make the claim that actuarial sentencing per se is unconstitutional. Again, I'm focused on particular variables. The ones that I think there are really viable constitutional arguments against are gender and the socioeconomic variables. There may possibly be viable arguments against family, against certain other family-related variables. First, gender. This, I think, will be maybe less controversial, but I think it provides an important background for the rest. So, you all are familiar with the law here. The state bears the burden of establishing an exceedingly persuasive justification for gender classifications. This is a tough test to satisfy. So, in addition to the requirement that the state prove a strong relationship to important government interests, the Supreme Court has also constrained the types of claims that can be made to establish that type of relationship. So the state is not permitted to defend gender discrimination on the basis of generalizations about what, on average, men and women tend to do. And that's true even if those classifications are empirically well supported. So I refer to this as the prohibition on statistical discrimination. Statistical discrimination is a concept from economics. So some economists argue that that discrimination can be rational when the characteristic in question is being used as a proxy for valid interests, like, say, crime prevention, and a statistically accurate one. But the Supreme Court has roundly and repeatedly rejected this distinction between statistical and other forms of discrimination, at least where race and gender are concerned. So on gender, for instance, in Craig v. Boren, the court struck down a drinking age law that discriminated against men, even in the face of a raft of studies showing that young men posed more than 10 times the drunk driving risk of young women. In JEV v. Alabama, the court said the prosecution can't rely on gender when striking juries, even if there are plenty of strong empirical studies showing a difference in the way jurors vote. There's lots of other examples. I won't go through them all now. In all those cases, though, the court conceded the point that the statistical claim was probably accurate, right? And in at least some of them, the state's interest was important, preventing drunk driving deaths, for instance. So why does the court reject these arguments? Well, the answer goes, I think, to the core of the Supreme Court's equal protection jurisprudence, which, for better or sometimes for worse, is highly individualistic. The core idea is that individuals have a right to be treated as individuals, not lumped in with others that share their characteristics. So not every person fits the average of their gender. So until the emergence recently of actuarial risk assessment, it was in fact vanishingly rare for the courts to explicitly account for gender in sentencing, at least in the last 60 or 70 years. Judges just don't say in open court, like, well, one co-defendant, these two co-defendants did the same thing, but she's a woman and he's a man, and everyone knows men are more dangerous, so I'm sentencing him to prison for 10 years longer. On the few occasions when that has happened, courts have been summarily reversed. And yet, actuarial risk assessments do exactly the same thing. They just mask it by putting it in the form of a risk score. So I think the prohibition on statistical discrimination really destroys any attempt to defend gender-based risk assessment because all of the justifications for it are grounded in reliance on statistical generalizations. And crucially, that same principle is also the reason that it's unconstitutional to discriminate in sentencing or parole based on socioeconomic factors. So lawyers and legal scholars have widely overlooked this problem, and I think that's because in other contexts we're used to thinking of socioeconomic discrimination as a losing constitutional argument. And it's true, in other contexts, it is usually a losing argument. The criminal justice system, though, is different. So for more than half a century, the Supreme Court has had doctrine that applies an especially demanding standard of scrutiny that blends equal protection and due process concerns. It's not identical to existing tiers or to other tiers of equal protection scrutiny. But it applies it to cases affecting indigent criminal defendants. So the seminal case is Griffin v. Illinois, which described the provision of equal justice for poor and rich as the central aim of our entire criminal justice, or rather our entire judicial system. And the court says, in criminal trials, a state can no more discriminate on account of poverty than on account of religion, race, or color, which is a strong statement because all of those other classifications get strict scrutiny, right? So in 1983, in Bearden v. Georgia, the Supreme Court applied this principle for the first time in the sentencing context. So it arose from a probation revocation hearing, right? So Bearden had been sentenced to probation, he lost his job, and the state wanted to get his probation revoked. The court unanimously held that this would be unconstitutional wealth discrimination. I'm going to skip the standard of review here. It's basically a form of heightened scrutiny, and it requires an assessment of alternatives as well, which is sort of a hallmark of strict-ish scrutiny. The state made a couple of arguments. I'm going to focus on the second argument. So the state said the defendant's unemployment increased his crime risk, and it introduced a bunch of empirical studies showing a link between unemployment and poverty and recidivism. The court roundly rejected this argument. It said its reasoning was really the same as its response to the statistical discrimination justifications in the gender context. The court says the state cannot justify incarcerating him solely by lumping him together with other poor persons and thereby classifying him as dangerous. This would be little more than punishing a person for his poverty. And I think that is exactly the problem with actuarial sentencing. The actuarial instruments lump defendants together with other people who share their socioeconomic characteristics and thereby classify them as dangerous. They punish people for their poverty. The Supreme Court has already unanimously held that this is unconstitutional. The case is still good law. It just seems like a lot of people have forgotten about it. I think that Bearden really directly invalidates reliance on socioeconomic variables for sentencing risk assessments. And so part of my sort of legal crusade has just been sort of like, hey, look over here, there's a constitutional case you can use. I've been trying to do like trainings and get defense counsel to know about it. I do think that most of the other variables in the instruments are probably constitutionally permissible. Obviously, race wouldn't be, but race actually isn't in any of the actively used instruments. Zeke will talk about the racially disparate impacts that it has, which I think is a concern for policy reasons, but under existing doctrine, not a basis for a constitutional argument. Other classifications like age and marital status, for instance, are routine bases for differential government treatment. I think that there is actually a potentially strong argument against the use of family background factors, such as whether parents or other family members have been to prison, or whether one grew up in a stable household. Parental incarceration, for instance, I think is very hard to distinguish from illegitimacy, which is a characteristic that gets heightened scrutiny. It's a highly stigmatized, disadvantageous trait over which the defendant has no control. That said, that would be a novel constitutional argument, whereas the rest of the argument I'm outlining here is sort of like established constitutional doctrine, and therefore easier, I think. Okay, so some risk assessment advocates have addressed really just the gender concern, and they've addressed it fairly dismissively, saying, well, gender discrimination might be subject to intermediate scrutiny, but it survives it because women really do commit fewer crimes, and taking that into account then serves the important state interest in crime prevention. I'm unconvinced by this for a few reasons. The first is the point we've already made, that is, the argument that women really do commit fewer crimes is exactly the kind of statistical generalization that the court has repeatedly prevented the state from relying on in formulating arguments for why important state interests are satisfied. That's not superseded by a claim that the interest is important. It's a limit on the type of argument you can use to show the relationship to a government interest. Let's ignore that for a minute. So if the state were allowed to rely on statistical generalizations, could it satisfy its burden to defend the use of these contested variables? I still say no, at least not with the empirical evidence that's currently available. And keep in mind that it's a state that bears a heavy burden of proof. I'm going to concede for the moment the point that actuarial risk assessments at least are capable of outperforming judges' individualized analyses of risk. I don't think all of the ones that are in use actually do, but I believe that the types of like fancy instruments or algorithms that Richard is developing probably do. That isn't really the question, right? In an equal protection case, what's at issue is a particular classification. And so the legal question is whether if we concede that we can make these generalizations at all, right? Then the question would be, does the addition of these variables serve an interest beyond like an instrument that didn't have them or that had other things instead. And I don't think the state can meet that burden. So the thing is that factors like gender and socioeconomics are correlated with crime. But once you already have, say, two defendants who have been convicted of the same crime already, and you're already accounting for past criminal conduct, there's several studies that show that adding these problematic variables it doesn't actually add very much marginal predictive value. I mean, of course, any variable you add is going to get you something, right? But getting another percentage point or two of accuracy to a model, I think, is not the kind of marginal gain that is sufficient to overcome a heightened level of constitutional scrutiny. Also, the Bearden analysis, at least for socioeconomic status, requires that alternatives be considered. And so, for instance, you might have to compare the existing instruments to an obvious alternative of an instrument that includes some characteristics of the thing that the defendant is being sentenced for, which is something that current instruments don't include. Would that be more accurate? I don't know, but it's the state's burden to show that it isn't. I skipped a number here. So finally, if the purpose of risk assessment is to protect the public from the defendant's future crimes, I want to argue that the risk assessment instruments are not actually asking the right question. So these instruments are meant to predict recidivism risk in the abstract. They ask, how risky is this person? What they don't ask is, how will the judge's sentencing decision or bail decision or parole decision affect that risk? And that's really the question for the purpose of protecting the public. And the thing is that almost everyone you put in jail or prison is going to eventually get out. And so just the fact that you decide, oh, we're going to send them to prison for 3 years versus 1 year, like, it's not obvious that that net protects the public more. The people who have the highest recidivism risk are not necessarily the people whose recidivism risk is going to be the most reduced by incarceration. In fact, it is perfectly possible that people who are more crime-prone to begin with may actually be more likely to be hardened rather than helped by prison. We really don't have the science in place to know what subsets of people will have their behavior changed the most by prison. It's actually a much harder task than the purely predictive tasks that today's risk assessment instruments engage in. It's a task that involves causal inference that's very complicated. And so we're just not there on the empirics. Okay, I know I'm just about out of time. I want to very, very briefly, I'll skip this point, I bet that is one factor among many. I want to very briefly address the question of, like, okay, but what about the comparison to what's happening now? Because maybe judges, they already consider risk. Maybe they're probably at least implicitly already considering all these problematic factors already. So just a few points on that. One is that, of course, judges...
Sonja, I'm sorry to cut you off. Can we save this for the discussion?
Yes.
Okay. We will come back to that very pressing, important question. Thank you so much.